Thank you very much, Madam Justice Taylor Alexander. I am truly humbled by your introduction and simply say that I have become accustomed to just saying, please introduce me with my name. But I really want to thank you for very, very much your touching words. I want to say how delighted I am to speak to you. I really do wish I was in Castries this morning, but Prime Ministers occasionally reshuffle their cabinets, and I have recently done so. And this morning is the first morning that my cabinet will be meeting in its new format. And I therefore crave your indulgence and ask you to forgive me for not being present. But since I am a dutiful counsel, I will say that I hope that I will have an opportunity to be able to see each and every one of your lordships, your ladyships, and those of you who represent the judicial framework that we have in this region, and to say how well we want to be able to work with you in a way that allows the three arms of government to be able to treat to it. I am not sure that we are at a position that we have escaped the growing pains of becoming adults as countries. And I start there because in a very real sense, all of us come from countries that are basically 60 years old or less. Jamaica and Trinidad celebrated their 60th anniversary this year. My own country is on the verge of celebrating its 56th anniversary. And many of us have had, therefore, the process of growing up as nation states before us, but we are still feeling very much the growing pains of that exercise. And what do I mean? I've chosen today to share a few thoughts on some things that are fundamental to our change and transformation as a region if we are to go from strength to strength. And those things which in many instances will confront you on a day-to-day basis. In some instances, you will be able to exercise a level of judicial activism, which I encourage, but not necessarily in the format that has been replicated or to be replicated as we saw in the United States of America, where there almost seems to be a determination to be a part of the executive, but from a different perspective. Judicial activism is healthy, and I want to continue to encourage it. Indeed, the first judgment of the Caribbean Court of Justice in Barbados' case, in Boyce and Joseph, reflected a level of judicial activism that we warmly welcome. But I say that these growing pains are here because fundamentally we are in the grips of all kinds of crises as we face, first of all, those from outside, the climate crisis, to the pandemic that has literally stalled our societies for almost 2.5 years, and 3, the emerging inflationary and cost of living crisis that has come as a result of the war in Ukraine. But in addition to that, we have our own internal crises. Many of us are continuing to see an outbreak of violence that is unacceptable and does not bode well for us to move to the next level. I asked myself, as we reflected on today with my officers, what really is also required of us at this stage. I feel that the whole issue of violence, as we've agreed at heads of governments, is a public health disease. And we have to come to grips with the fact that unless we change the psyche of our people and unless we allow our people to be to not be desensitized on the whole issue of violence and death, regrettably, we will continue to see more of it. I feel strongly, as we've discussed, that we cannot continue to have a legal system that imposes criminal penalties for every breach of the law. And regrettably, in many of the colonial pieces of legislation that we have inherited, that has been the case. So for every breach, whether it is a regulatory breach or whether it is a substantive crime, the notion of fine and confine has been the penalties which we have accepted. We in Barbados are trying to move away from that and to introduce a system of civil penalties that will allow civil penalties to be used for regulatory breaches. And as I've said to the Cabinet recently, we need to introduce penalties that also allow those who dare to breach the social capital of a nation must be prepared to repair the social capital, and therefore the penalties which are imposed on them ought to relate to those things which are necessary to repair that social capital. And what do I mean? If you are prepared to litter, if you are prepared to curse, if you are prepared to do things that bring down the social capital, well then let us put you to do the community service in areas that will repair the social capital. With respect to the regulatory breaches to which I've just spoken, if you are the ones who want to be able to have a system of governance that ensures that people comply, let us not believe that the only mechanism for compliance is a criminal penalty. And I give you perhaps one of the ones that stands out in my mind as an example. Former Prime Minister of Trinidad and Tobago, Basilio Pandey, went before the law courts in his own country on the issue of breaches with the integrity legislation there. And those breaches that were occasioned were not substantive, but were procedural. Now, we ought to have different ways of separating penalties for regulatory breaches than criminal punishment for substantive crime. You commit rape, you commit murder, you commit burglary, you commit any of those genuine criminal offenses, criminal sanctions, criminal punishment. But when we start to deal with regulatory breaches, then I really do believe that we need a unified system of civil penalties across the region. It is important to move from the Victorian approach to law, and also let us begin to understand, and we can learn from indigenous tribes and indigenous people across the world, that what matters is how we repair the damage that is done. We as nation states are talking about reparatory justice for what has been done to our own and our people for centuries. We cannot now be the ones seeking to have only an adversarial system of justice which only serves to divide rather than to retain and repair the whole. And I hope that some of these things will resonate with you this morning, because our region more than ever needs to be able to treat to these issues in a holistic way, and that recognizes that in many instances those who are finding themselves before the law courts could, with a different approach, not be capable of the level of recidivism that regrettably we are seeing in small states. And this brings me to the next issue, which is difficult, because universal values are universal values, and universal rights are universal rights. But let us not forget that they have different consequences in the way in which we apply some of them. And this is the one that has given me the greatest discomfort. And for someone whose background has been in the area of the practice of criminal law, you would appreciate that this is not easy for me. I believe that people are entitled as a right, and we must protect it at all costs, to due process. I believe in the presumption of innocence. I believe that there has to be fairness in our systems. But I also believe that small societies, such as ours, cannot withstand the rate of recidivism, particularly with people on bail, that we are seeing in our societies. Regrettably, there are too many instances across the Caribbean where persons who have been charged with murder on bail again and are committing their second and third and fourth murder. Our societies are asking us serious questions, and we have to be prepared to do the balance. I believe that the balance can be found in expeditious trials. There is no right to bail, as you know, but equally, we have to be able to ensure that persons are not automatically given bail simply because the case has taken too long to come on and to be heard. And the consequences of that happening are tearing our societies apart, because really and truly, what does a man have to lose when he's already facing the greatest penalty that a country has to impose on him? And these are the things that are serious and real, and I hope that you can add to the conversation with respect to how the system of the administration of justice can be improved to ensure that persons charged with murder or persons facing gun crimes can all have their cases heard within a 6 to a 9 month period at first instance, and that the entire appellate process should take no more than 12 to 15 months thereafter. If we can do that, then it becomes a moot point to discuss the issues with respect to whether a person who is on a murder charge should be given bail or not. I want, however, to not just only dwell in the area of the criminal law, but I'd like us to also reflect on some other aspects that are causing us grave concern and that we may well have to address in different ways. One of these areas relates to the development of administrative law in the region. I think it's been one of the greatest achievements of the region as a check and balance on the powers and the ability of the executive to ensure fairness and equity and reasonableness and transparency with respect to its actions as a government. I welcome the fact that Barbados' Administrative Justice Act is over 40 years old. But I ask myself as Prime Minister and as Minister of Finance, whether the time has not come, as I've discussed with that great legal luminary who is no longer with us, Sir Roy Marshall, who was a previous Vice Chancellor of the University of the West Indies and a Vice Chancellor of the University of Hull, and for my own benefit was my special advisor as Attorney General when I served in that post between 2001 and 2006. Whether the time has not come for us to impose caps on damages with respect to administrative law breaches. The truth is that the breach, if it has occurred, must be recorded and called out. But what is also equally true is that our countries, in a very strange way, facing all that we face as small island developing states or developing countries, cannot afford unlimited damages, particularly given the fact that more often than not, many of these breaches are not even within the knowledge or purview of the executive at the highest level or the Ministry of Finance. And that when you have officers in large public services acting in ways that are in breach of their own rules, but nevertheless so acting, the state is held liable for it. I believe that we will have to be proactive going forward in the same way that I recognize as that great former Prime Minister also of Barbados, Sir Harold Bernard St. John, told me at the beginning of my parliamentary career. He says, young lady, in our lives, you are going to have to come to grips with the fact that many of the things that we accept by convention will have to be legislated, largely because people come from different backgrounds and different perspectives in order to be able to deliver the work that is required as a nation state. And whether it is as simple as them having different influences depending on where they were educated, or whether it is different value systems because of where they were born or raised, the reality is that if we are to have certainty, we will need to be able to codify much of the conventions that we take for granted now. I use that as an aside, but the truth is that we have reached a point where I believe that there has to be a legitimate conversation about the capping of damages in administrative law. I do not believe that those who framed the legislation ever intended that the level of punitive damages or damages simpliciter was to be able to create a significant fiscal problem for government, but was more to reflect the fact that something was done and somebody has to pay the price for what was done. If that is the case, then let us agree, yes, we can do it, but let us cap the damages as has been done in other areas of the law. I also want this morning to speak to you frankly about a matter of where we are with the public confidence in our areas of establishment, be it in government or be it in the rule of law. You know, one of the reasons why I personally support the decriminalization of marijuana is because in my own country and over the course of my own life, I have seen people start to literally disregard the law. When I first came to public life, people would stand up at public events, football matches, and they would go and hide behind the stadium, or they would go down the road and smoke and come back. In the last 5-7 years, we have seen people just literally determine that it matters not. And I'm talking about both men and women. And they stand up and test the authorities in many instances. And where you're in a match that has 2,000-3,000 people on the ground, and you have maybe 10 policemen. I have watched the policemen literally retreat while others continue to do as they wish. The most important thing in a civilized society, the thing that defines us as nation states, is our ability to maintain the rule of law. And we have to ask ourselves as Caribbean people whether we have not reached a moment where the ultimate defense of the rule of law is what is necessary to save our societies and to preserve our capacity to grow from strength to strength. And I'm not only talking now then about the decriminalization of marijuana, but there are other laws within our midst that are regrettably observed more in the breach than are complied with. And when we reach a stage where laws are observed in the breach, then we as the executive, in my own view, have an obligation to change them. Because if we don't change them, it then means that there continues to be that aggressive disrespect for the rule of law, which can only serve to hurt us as a nation state and as a people. I trust and pray that this is one of the areas that will engage not just members of the judiciary, but all Caribbean people, because what is at stake is our quality of life if we are to be civilized societies governed by the rule of law, given those who do not have the power of might a chance to survive. More often than not, the law is the only protection that people who are vulnerable or who are not strong or who are not wealthy have in order to protect themselves and the dignity of the life that they want to live. I really do hope, therefore, that we reflect on these matters and to ensure that we grow from strength to strength and to emerge from the growing pains, we need to be able to be sensitive to much of these things. The last point that I want to raise, and this, regrettably, every month I go to a different parish. And I sit down and I allow the parish, members of the parish to speak along with my ministers and heads of different agencies, so that we hear what the population is saying in an unfiltered way. Because whatever they have to say, it is important that we hear and understand and are in a position to respond to it. And last night we did Christchurch Speaks. And it was unique because it was perhaps the night when the majority of the citizens chose to take on the system of administration of justice as well as the policing of our nation. And regrettably, we have to pause and ask ourselves, how can we be more responsive to what is emerging as a growing lack of confidence in the system's ability to meet the needs of ordinary people? I just finished speaking to you about the rule of law. I believe that it is the glue, it is the most important thing. In our own covenant of hope, which is what guides us philosophically as a political party, which we settled back in 2016, we have the ability to understand what matters to us most as a government. And the first thing that we put our commitment to in terms of our spending is the rule of law, the protection of the rule of law, because without that, the society cannot function. We then go to public health and education, etc. We have a situation where too many of our citizens are waiting for justice. Too long. And the delivery of judgments that go beyond 6 months, we use 6 months as a measurement. But the truth is that I feel strongly that we can do better in terms of the immediate delivery of judgments. But secondly, what people are complaining about is 6 years and 5 years and 7 years and 3 years. And this exposes the government to further liability as a result of those young and not so young lawyers who are creative and who may want to argue that there has been a breach of due process and that justice delayed is justice denied, and that our constitutional compact with them does not admit of that. We have therefore to see how best all of us, those of us in the executive, in the case of criminal matters, working to make sure that the systems are deconstructed and reconstructed and intended to serve our people. We have to do it in the civil law with the registries and the systems that we put in place, and deconstruct and reconstruct how we take evidence and how fast we move. And perhaps, with all due respect, and I don't say this in any negative way, we perhaps in our judgments not need to believe that every judgment needs to be a treatise, and that what matters more to people is the decision rather than the quality of literature, the quality of writing, the quality of references, the quality of quotations for us. And so long as the judgment is sound, then what matters more to people is the decision and the determination. I say this without hoping that I have stepped on any corns. But I'm saying this as a citizen of this Caribbean civilization, recognizing that where people lose faith in the institutions that they have, then they are more likely to take matters into their own hand. And I believe that the solutions that we bring to the table have to be collectively found, have to be discussed, have to be tested in terms of whether they're sustainable, affordable, etc. But more often than not, we can afford them. What matters, however, is the acceptance that there must be a red line in the sand, and that any judgment that goes beyond 6 months, and I would hope that they come within 2 and 3 months at most, and in some instances contemporaneously, any judgment that goes beyond 6 months is hurting our societies and our civilization. And we ourselves have passed amendments, but to pass an amendment alone without having the acceptance internally and intrinsically of all involved will not solve the problem. And I hope that one of the things that we will discuss going forward, and that you will discuss in your conference, is how best do we ensure that our Caribbean citizens do not lose confidence in the system of law to be able to resolve their issues. I feel strongly, and I've said to my people here, that I don't think we've made sufficient use of systems of mediation and conciliation. Has the time not now come for us to also take justices of the peace and provide training to them, so that in matters pertaining to minor offenses and minor conflicts and petty debt, that they're in a position at the level of parishes or districts to be able to resolve some of these issues? Because I accept that part of the difficulty is that our people have become far more litigious than they have been before. And therefore the volume of cases that are coming before the courts place tremendous pressure on our judiciary. But I do believe that we are at that point. And I hope that we can get some feedback back from you as judicial officers on some of these complex issues, because in the true spirit of the separation of powers, I believe that you have a perspective that ought to be shared with us as members of the executive with respect to broad policy, without either of us interfering or getting involved in the day-to-day running of each other's business. But we need to hear you, and we will welcome your views on this and other matters. The very, very last point, perhaps, and as an adjunct to that, must be the issue of constitutional and parliamentary reform. Because if we're going to look at how we reform our judiciary and reform the expectations of our citizens, the question will beg itself, what of the Constitution? Most of our countries still carry the Constitution that we had at independence, which quite frankly speaks predominantly to the role of government, but not sufficiently to the role of governance. And that is the bridge that we now have to catch and to cross if we are to ensure that these constitutions are proper living documents suitable to the times in which we live. Similarly, our parliamentary reform needs to be more responsive to the nuances of Caribbean civilization, and to believe that it has to slavishly follow Westminster, especially in this year of 2022, may not necessarily be the wisest of decisions or beliefs that our people can anchor themselves to. We look forward, therefore, to hearing some of what comes out of your conference. I personally believe that we have reached a stage where we ought to be able to have a pilot, and I say so to all of your lordships from the different territories. I feel that in small societies, we benefit when there is some oxygen from outside. And what do I mean by that? That if we can settle on a framework that can be put before the Conference of Heads of Government, that can allow, not coming from us, but coming from you, because of the sensitivity with the separation of powers, but that allows for the exchange of members of the judiciary for periods of time, so that a judge from Barbados can sit in the OECS court for 3 months, or a judge from the OECS court can sit in the Court of Trinidad for 3 months, the High Court of Trinidad, or Guyana, or Jamaica. I believe that that ability to have a certain percentage of our judges be subject, and particularly where judgments are going to be given swiftly, will have the benefit of adding some freshness to our judiciary and adding some greater experience to those who are serving in ways that hopefully will inure to the benefit of us all. So my dear lordships, your lordships and your ladyships, I really do wish I was in Castries this morning, but as I said, due to the exigencies of the moment with respect to the cabinet reshuffle, I cannot be there. But I do hope that some of these issues that I've raised with you this morning will give you the ability to reflect and to share your perspective. These are things that, as Prime Minister of Barbados, that I've been reflecting on for some time. Some of them are in the process of us addressing, and some of them are still at the stage of conversation. And I therefore would more than welcome your perspective on some of these issues, so that we as a Caribbean civilization can go from strength to strength to strength. We are at a difficult moment in our history, and we are at the stage where, even as we speak, the number of countries that are coming perilously close to a debt moment are regrettably too many. That is why we have launched the Bridgetown Initiative globally, recognizing that we need to be able to address liquidity for countries urgently, and that is affecting what countries can do for its citizens because of the triple crisis to which I referred earlier. That we need to be able to accept that development capital needs to be long-term. We want to spend more money. I want to establish a family court in Barbados that removes the distinction, for example, between the magistrate's court, where women who are not married go and stand up like if they're cattle, and the High Court, where married people go and wait long. We need to have a single family court that addresses the issues of how to keep the family whole, even in separation. And why do I say so? Because it's the children that suffer, and it's the children that carry the scars for life, and that those children will not be in a position to be the most productive citizens if we can't. But in order for us to establish that family court, it takes dollars. We've done a commercial court recently. I've increased the number of criminal courts. Even as we speak, I'm increasing them by another 3 in order to deal with the fact that 80% of the murders that are before our law courts today predate us coming to government in June of end of May of 2018. And almost 80% of the gun cases predate our coming to government. And if therefore we are to find the money to be able to address some of these issues within the justice sector, we need to be able to have access to long-term capital. And regrettably, the world has siphoned and pushed countries like ourselves into only accessing short-term capital, which cannot build our nations. I use the example all of the time as to the fact that when the UK literally raised money to fight World War I in 2014 and 2017, by 2032 it recognized that it needed to reissue that bond and to give itself time to repay it, because it could not pay both to fight the war and fight to rebuild the nation while first servicing short-term capital. They did it for the UK. When Germany lost the war, the great powers of the world came together and determined that Germany should not have to pay more than 3% of its debt service. 3% of its export revenue, in debt service. And these are the things that they have allowed in the developed world, but have regrettably not been replicated in our world. I believe that we need reform of our justice sector. We need to also be as creative in the 21st century as others were in the 20th century. I make the point, and the Chief Justice of Barbados is there, and I hope he will share it. Title suits, foreclosure suits, that, we call it whatever you want. They have different names here. But that ability for Barbadians for almost 100 years to translate possession of land into ownership through a fictitious mortgage suit, ultimately ending up in a registrar's conveyance, which is perfect title, allowed our people to be able to transition from poverty to being able to leverage the assets that they had possession of in the banking system in order to move to the next level. These are, in the way that Hernando de Soto talks about in his great book, The Mystery of Capital. These are the things that matter. But if we can't borrow or access long-term capital, and if long-term capital from the international financial institutions does not move from billions to trillions, and if we don't recognize that instead of only dealing with the reduction of poverty, which is and must be the ultimate noble goal, that the World Bank also has to deal with global public goods, also has to deal with the fact that whatever we do, a pandemic anywhere can decimate the world everywhere. Or the climate crisis, as we are seeing with the apocalyptic floods in Pakistan, or with the heat waves and the melting of tarmacs and the wildfires that we've seen in this summer. Extension of what we face in the region from hurricanes and groundwater crises, and the destruction of our coastal environment, and of course the sargassum seaweed, which continues to be part of the chronic nuisances that we face and that reduce the ability of those people on the coast to be able to earn properly because of the toxic smells coming from it. These are the things that we must fight, and we continue to fight. And finally, that even when money is available, because many of our countries have had to carry the burden of adjustment without the sensitivity to size, be it related to the WTO coming in and refusing to accept special and differential treatment as part of our reality as small states, that in its failure so to do, we have seen the decline of our manufacturing and agricultural sectors in every country in the region after the WTO, with the exception of maybe one country. And secondly, that with Resolution 1393, as you would most probably know, that this slavish belief as to what is necessary to fight money laundering and terrorism financing has so hobbled us that it has made us anti-competitive and is used as a whip against us in order to restrain what we can do and to impose an uncompetitive environment within which we must function. These things have all happened in a way that makes it difficult for us to survive as nation states. And we simply say that our balance sheet, therefore, in order to fight these things, in order to fight the new global public nuisances and risks that we have, we are constrained because our debt to GDP ratio in almost every Caribbean country has gone high, not because of profligacy or corruption or any of those things per se, but it is because of us having to function in a non-competitive environment, having come to independent states without the benefit of capital being deployed to us in terms of reparatory justice in any way. And therefore, we can't develop key parts of our society, like the judiciary, like our education sector, like our health sector, unless we find greater room. But the climate crisis, as it comes down, is real. So what are we suggesting also finally in the Bridgetown Initiative? That we have an international balance sheet that allows us to put that money on the international balance sheet rather than imposing it on our own peculiar national debts, which then crowds out our ability to spend on you, spend on health, spend on education. So my friends, I've spoken far longer than I intended to, your lordships, your ladyships, but I hope that I've left you with a few thoughts. I'm not feeling the best, and I hope I wasn't too nasal this morning, but I hope that you are in a position to be able to reflect on some of these things and to share with us as leaders in this region so that we can collectively make this great Caribbean civilization the best that it can be. Thank you, and may all of you be blessed as you undertake the work as judicial officers for this great civilization. Thank you.